Well, good morning, everyone. Welcome to How Can Realtors Avoid Getting Sued? My name is Pascal Vivian, Member Services Specialist here at JTHS Miami. To let you know, this class is being recorded and it'll be available later on this week on Rami's YouTube. Please keep yourselves muted. If you do have any questions, please put them in the chat. We'll answer them as they come along. And in any case, I'd like to introduce you to our instructor today, Rami Harado. Please take it away.
Thank you so much. Good morning, everybody. Thank you so much for joining me today. I like to make my classes interactive, so please do put any questions that you see on the chat. I do see the chat here. So let's get started. This class is about how can realtors avoid getting sued. In reality, nobody can avoid getting sued because we live in a very litigious society. However, we could do certain things to protect our personal assets so that if you are ever sued, you are protected, right? So one of those things that I like to tell people to do, realtors, is that they shouldn't be operating in their own personal name. Florida law allows you to form a limited liability company or a corporation and have your license in the name of that liability company or corporation. And that way, all your personal assets will be protected from a lawsuit. If you're operating under your own name and somebody sues you, all your assets are basically at risk. But if you are operating under an LLC or a PA, a professional association, only the assets that that company has would be at risk, and that company is not going to have anything because all you would use that company for is to receive your commissions. So I advise agents, realtors to operate not individually, but under a corporation so that you have some or an LLC also. Even though in Florida, single member LLCs don't offer that much protection, the law changed in 2015. So probably I would recommend a corporation. So real estate agents are frequent targets of lawsuits. A common lawsuit that we see involves the buyer of a property suing the seller and the seller's agent for failing to disclose the property's defects. In some cases, the buyer also sues their own agent for the transaction. The lawsuit alleges not only negligence, but also that the seller and agent conspired to conceal the defects in order to facilitate the sale at a higher price and earn a higher commission. This I do see a lot. A buyer will come in, time has passed by, maybe a month, 2 months, and they start discovering everything in the house, issues and stuff like that. And what they want to do is not only sue the seller, but sue the realtor that helped them buy that property because they think that the realtor knew and failed to disclose. So what I recommend all agents is if you're involved in a transaction, whether you're representing the buyer or the seller, you should disclose everything that you're made aware of. So that way nobody can come after you and say that you failed to disclose, because it is, it's something that happens a lot. People will come after later and think that you hid something in order to facilitate a sale, and they're always trying to find ways to file lawsuits. So if you know of something for sure, you want to disclose. Don't fill out the seller's disclosure. I have a lot of agents that deal with a lot of foreigners, right, in South Florida, and they are the ones filling out the seller's disclosure because the seller doesn't understand English or whatever it is. Don't do it, because then you are assuming liability. It's as if you're making those statements. So if your seller is doing a seller disclosure and they ask you to translate, help them fill it out, don't do it because you're assuming liability. Let them do it. If they don't want to provide a seller disclosure, then they really don't have to, but you shouldn't be the one preparing those documents. Also, very important to know the relationship that you have with your client, with your buyer, with your seller. We in Florida are presumed to be, or agents are presumed to be, transaction brokers, right? So automatically, before you used to have to do a form, now it's, it's presumed that way. However, I always advise people to have, something in writing so that it's clear that you are a transaction broker, that you're not a fiduciary, meaning that you're not just representing one party, you're representing the transaction. So advise, have all your clients sign documents stating that you are a transaction broker. And then at the end of the representation, one thing that you guys can do that I can't is you can make people sign something called a hold harmless agreement. So a hold harmless agreement basically says that they release you from any liability that could have arisen during that transaction. As an attorney, I cannot make my client sign that unless they're represented by another party, by another attorney, and so forth. So I don't do that. But you as agents can do that, and then that way you decrease your liability. So make them sign something at the beginning that says you're a transaction broker, and once you're done, you could have an agreement that's called the hold harmless agreement, so that they release you from any liability that could arise, and that way you're further protected. Going back again, failure to disclose, that's very, something that we see a lot, but we want to disclose everything that we know. If we don't know, then we can't disclose. Breach of duty. This is also a common lawsuit against real estate agents. You're supposed to act in the best interest of the client. They put trust in you. So you want to make sure that you're abiding by any and all ethical regulations, any and all duties that you've agreed to provide. You want to make sure that you document everything. And you also want to provide the client with information. A lot of agents tell me, Romy, I told them to be represented by an attorney. I told them to, to consult with a tax accountant. And now they're blaming me and saying that I made these representations to them. And I said, just put it in writing from the beginning, right? So if you advise a client to go seek legal help or tax help or whatever it is, and they don't want to do it and they want to proceed with the transaction, if you put it in writing to them in an email or something, later on when they come back and said, oh no, you told me this, you presented this, you have something to back up and say, no, I didn't. I asked you to go consult a professional and you decided not to do it and proceed with the transaction. So you always want to have everything in writing, some email, confirming text message. Everything can be used to protect you, but you have to have it in writing. Because if you just say it, then you have no proof of what you said. Okay. Breach of contract. You want to make sure that whatever documents you have with your clients, that you're abiding by whatever is written there. If you make your client sign a buyer agreement, which I see a lot of agents do nowadays, and that's great, then you want to make sure that you're compliant with whatever that agreement says. It's very easy to just make somebody sign something that you didn't fully understand, and now you're breaking the contract because of a clause. You say you were going to let them know this or let them know the other, and then you don't. So you want to make sure that if you're making them sign something, you abide by whatever that contract says. Negligence is also something that I see a lot. If you are, for example, taking people to see property, pre-construction or, abandoned property, sometimes some probate properties that may, have all this bunch of issues, I always tell my agents to make the client sign something that releases you from anything that they may find at the property, especially those properties that have been abandoned for a while. You don't know what you're going to find. We had a particular case where an agent took somebody to see a property. The agent didn't know that the person had allergies, cat allergies, and there was a cat in there. And then they wanted to come after the agent because the person broke out in allergies. And to me, that didn't make sense. I thought, why didn't you let the agent know? And sometimes you don't control what you're going to see. So the best way to protect against that is to make them sign something at the beginning. So you make them sign the transaction document and you make them sign some type of agreement, something that releases you from liability. You're going to show them this property, but you have no control of what they're going to find there. Because if they fall, something happens, they try to come after you. This is where we see a bodily injury. Sometimes, if a client is injured during a showing and you're found liable, you'll be responsible for reimbursing any costs related to the accident. I know that you guys don't take people in your car anymore. I think that's great because otherwise you're exposing yourself to further liability. Failing to keep client data secure. If you're assisting people in obtaining loans, not as a mortgage broker, but you're basically, introducing them to mortgage brokers, and you're serving as the middle person, the one sending the tax documents, the one keeping all this information, you're assuming further liability because if those documents end up in the wrong hands, they're going to come after you for failing to keep the client's data secure. So my advice, don't get involved. Do not send wire instructions. I know a lot of you guys don't do that anymore. Don't confirm it for the client. Don't send tax documents. Let them send it themselves to the mortgage broker. Because if you take any client data and you fail to keep it secure, you will be found responsible. So we definitely don't want to do that. Misleading clients. Every real estate agent strives to make their property stand out from the crowd. It may even be tempting to exaggerate here and there about the features or the condition of the house. However, this kind of deception can end disastrously for agents. If a buyer feels misled about anything, a lawsuit typically follows shortly after. Always be truthful about claims you make about a property with no room for misinterpretation. A misleading statement might help you close a sale, but it may also lead to legal action and financial loss. It's not worth the risk. This I see a lot with inspection reports. So you as an agent tell your client to do an inspection, and they do. And then they come back with the report and they show it to you, and then they expect you to tell them whether they should buy the property or not. Don't get involved in that because you're not, unless you are a property inspector, a contractor, you really won't know, whether it's something that can be easily fixed or whether it's something that requires further work. And if you start explaining stuff to them, they can say, and they can use that you were misleading them to force them to buy the property. So what I recommend agents to do, if you receive an inspection report and the client needs information, develop relationships with contractors. I have also relationships with contractors who I can say, listen, I have a client, here is inspection report. give them some type of quote of what everything would cost so that they can make the decision. The client can decide whether it's worth it for them to pursue or not. Get, maybe 2 or 3 contractors that you have, develop business relationships with, so that when your client sends them the report, they're able to come back with a quote. And then eventually, of course, they're going to get hired. But the point is that you're not the one explaining to the client, yes, this is something easy fix or not. A professional is doing it. They are the ones that are going to be responsible, and they may end up getting the client or not, but at least that further releases you from liability. Nobody can say that you were misleading them because you're not. Representing clients in unfamiliar territory. This is also something that you need to know. For those of you that are just doing real estate, or for you guys that are also selling businesses, it is so important to understand the industry that you're in. For example, I had a case where a client wanted to buy, it was a property, it was commercial property, but they wanted to buy. And basically, if you buy, for example, a body shop, a business body shop, unless you buy the whole company, you're going to lose the license. So in this particular instance, there was a business broker, a realtor, representing the client in both the purchase of the property and the purchase of the business. But they didn't know that you can't just buy the business with a new company. You have to structure it in a certain way, because body shops, they won't let you get a license for that anymore. Once you have it, you need to keep it, you need to structure it a certain way. So the agent, whoever was representing this transaction, should have become familiar with the type of business they were representing, should have understood at least, or getting advice on how the licensing works, because otherwise that could have been disastrously. Also, for example, in certain counties here, we require a certificate of occupancy, an inspection before you buy the property by the city. They come and they see whether, the property has some violations and things like that. You need to know which counties require that, which cities require that if you're representing somebody in unfamiliar territory. There are also very particular things about certain counties and certain cities. I'm not saying don't represent clients anywhere in the state of Florida, but become familiar with whatever particularities of that particular city or county if you're going to be engaging in those transactions. Giving legal advice. Of course, you're not allowed to give legal advice, but clients think that you guys, need to explain the contract, this and the other. The contract that is made by the Florida bar that you guys use, it's fill in the blank. You can fill it out, you can do that. But I don't want to see people doing like addendums that get creative. Like one time I saw an addendum that basically explained how the loan was going to be structured, and it was a seller loan. So the client, my client was actually the seller for the litigation part, said, I never agreed to give this loan. I don't know why my agent put here and said I was going to do seller financing. So at that time, what we needed to do to get him out of the deal is to sue the agent, because the agent took it upon themselves to explain how the seller financing was going to work. The client didn't know they were agreeing to seller financing, and so the buyer was pushing for it. They're like, no, you agreed to give me seller financing. Here is 30% down, and you're to sell me the property. And the client was really not aware. So don't give legal advice. Don't prepare documentation outside of just filling the blank, because you might be assuming liability. The clients may want to sell and they may agree to it, but then later they'll say, no, I never agreed to that. The agent took it upon themselves to do it, and then they might come after you for that. So don't give legal advice, don't give tax advice. Develop relationships with professionals that they can freely discuss, a question here and there, and then they get their advice. For example, a lot of people have issues with FERPTA, right? It's the withholding tax when foreigners own property. And there is a lot of misconception of when FERPTA applies or when it doesn't, that 15%. It's a quick email, it's a quick call to explain it to a client, whether they might be facing FERPTA or not, but it shouldn't be you the one that's doing it. They should either get advice from a CPA or from an attorney that is familiar with that, because that can make a big change. We had a closing where the person didn't know that 15% of the gross price was going to be withheld because they were a foreigner, and they were only making like 100,000, and 15% was a lot more. So we want to make sure that you're not giving advice. If there's any questions regarding particularities in real estate that we deal with, like FERPTA, 1031 exchange, work with professionals to provide that advice. Because if you give them any advice and things go bad, they're going to come after you. Failing to disclose, potential lawsuit, defects, right? So what do we need to disclose? If you know of any permit or code violation, you should be disclosing that. Your seller should. If you're made aware, you need to let them know. Any type of water issue needs to be disclosed. Any type of structural issue during the inspection, buyer must be made aware of, any type of remodeling or anything like that. Don't ever, if you see like some water or something, say, oh no, that's nothing, that just needs paint. Because when you say those things, then you're assuming liability, and we definitely don't want that. Any type of wiring and electrical issues, all of those things need to be disclosed. So what do we do? How do we be proactive? What do we need to do? Well, we want to make sure that you understand the duty that each party has. You want to make sure that each party signed the contract. This is so important too. So in real estate, you guys have the form contract and it comes in, you fill it out, you send it, the buyer signs it, then the seller signs it. And then if there is any change in it, that needs to be initialed too. A lot of times people come to me when the deal is already bad and I look at the contract, and the easiest way to get out is by showing that one thing was not initialed. Because if something was not initialed, then that's not a valid contract. That was a counter offer that was never accepted. And then you can use that to get out of the contract. So if you, one thing, know who's signing, right? If you're selling, you want to make sure that the person who owns the property is the one signing. If it's a trust, you want to make sure that the person that's a trustee is signing the contract. If it's in probate, you might want to wait until the probate has started to see who's going to be the personal representative. If it's a company, this is so important. You want to make sure that the company is there completely, like the name of the company and what state it's incorporated in. And you want to look at corporate documents to see who has authority to sign or not. Because that's another way to get out of the contract, which is, oh yeah, the property is owned by an LLC, but the person that signed the contract had no rights to sign because they were not an officer, they were not a manager, they were not a member, they just simply signed their name. So it's very important to be proactive. If you're dealing with property owned by husband and wife, my advice, always get both husband and wife to sign your listing agreement and of course your contract and every initial. Why? Because in Florida, when property is owned by husband and wife, each of them owns 100% of the property at the same time. So unless you get both of their signatures, they may use that to get out of the contract, both with the listing and the actual contract. Also, you want to make sure in the contract, if there is any type of assignability, you want to identify the parties. You want to make sure that you are putting the right folio. All those things are super important, and you want to make sure that it's clear so that there is no issue later on when it goes back and forth. You're not going to face potential litigation. Deadlines. This is so important. I had a client and she told me, Romy, I placed an offer on 4 lots because the realtor told me to. And I look at the contracts and I'm like, did you make the deposits? And the deposits were due 3 days after signing. And she's like, no, the realtor told me it was okay. No, it's not. If the contract says that you need to make a deposit by a certain date, it is important that the client does that, right? Because otherwise they're already breaching the contract and they're going to say, why didn't you tell them? I really like when the realtors put together those emails with all of the deadlines and they send it to all the parties. I think that's great to keep everybody on track. You want to make sure if you have a client with a financial contingency, and this is super important, that you let them know before the contingency expires that either they accept it as it is or they can back out of the contract, right? Because if they extend and the financial contingency is not extended and they're not able to get the loan, they're going to lose their deposit and then they're going to blame you saying that you didn't tell them. So my advice when I'm representing a client is, and for you guys too, I send an email and I'm like, listen, your financial contingency, it's going to be done this date. You have 2 options. Proceed as is because they don't want to increase the financial contingency, or simply cancel the deal if you're not able to get the loan. So you want to make sure that you have all of that in writing. So later on, again, they don't come out. Leases are so important when you're when you're representing a buyer. You want to make sure that they get copies of all leases, and you want, they need to read them with an attorney, especially if you're representing them in commercial property, because they may be buying a property that has, a lot of issues with the tenant. They need to get stopple letters, basically the tenant to sign how much they're really paying for the property, because you might be surprised. The lease might say one thing, but the tenant thinks something totally different. So whenever representing the client, either residential or commercial, I want to look at all the leases. I want to get stopples so that the client buys the property understanding what the relationship is with the tenant. Reoccupancy certificates, depending on the city or county, you might be required to have that, which means it's an actual inspection that the city does of the house that you're representing the people to buy to make sure that there are no open violations. We have that in, for example, in El Portal and in Hialeah. So if you need to do those, make sure they're done with time, because that's when they are going to realize if there's any code violations or any build outs that they did without permits, and the city might come after them for that. Okay, so I mentioned to you having a corporation or an LLC to have your license and be basically, now you're not doing it personally, you're doing it through a corporation. So therefore the liability will stay with that. Another thing that you guys need to have is, of course, insurance, right? Insurance, it's great, but you need to read the policy. A lot of agents come to me when they already are facing a lawsuit and they tell me, Romy, I kept paying the errors and omissions, and now my broker's telling me that I'm not covered for this and this and the other. If you're paying errors and omissions insurance, the most important thing that you need to do is read what it covers. Don't just assume that because you're paying it, it's going to protect you. I had agents who were paying errors and omissions insurance, and then the broker told them, no, you're not covered. They were not even covered in the policy. So all of you guys out there, girls out there, if you are paying errors and omissions insurance, ask your broker for a copy of the policy. Make sure that you're covered, have the policy with you so that you understand. And if you're not paying for that, consider paying for it, but also understand the policy, because there's no point in having insurance if it's not going to cover for what you need. And she had liability insurance. She received a lawsuit because somebody was alleging that they were infected in their nails. So I said, okay, great, you have liability insurance. Let me look at your policy so we can send a letter to them and let them know that they need to defend this case. I read the policy and it says that they have a germ exclusivity. It didn't cover germs. So that was an exclusion. And I'm like, oh my God, the reason why this person was saying that they were infected, it was because of germs. And this is a spa that shouldn't be taken out. So I asked her, why do you have that exclusion? And she told me, well, my agent told me, my insurance broker, that if I didn't have that, if I excluded that, I would save $600 for the year policy. And I'm like, oh my God, because of saving that $600, now you're going to have to hire basically us to defend you and charge you $500 the hour. And God knows how much it's going to be, because litigation can be really expensive. So what I'm trying to say is read the policy, make sure that it covers what you need it to cover, and fully understand it so that you're protected and you don't have surprises like that. PAs, again, I highly recommend it. LLCs in Florida, no, not so much. And I'll explain to you why. The law changed in 2015, and single member LLCs in Florida don't offer as much liability protection as a multi-member LLC. You guys, as realtors, you're allowed to have your license in either a corporation or an LLC. However, you can only be the only owner. So you would have to create a single member LLC, which won't give you as much protection. Whereas if you create a corporation, which is called a professional association, and you are a single shareholder, that one does give you liability protection because the law didn't change for that one yet. So my recommendation is have a corporation, a professional association, file for S Corp status so that you only pay tax once, not twice, like in a regular corporation. And this way you're going to have, a separate legal entity. This is, your license holding entity, and that one is going to be the one that has all the liability. And basically, it's not going to have any assets, because while you'll have your bank account for the company, that bank account is commissions in, commissions out, commissions in, commissions out. And the PA is not going to own anything. Now, I have clients, realtors, that they did form a PA, but then they started buying assets with that PA. Then you're exposing those assets. You're not supposed to. In order for you to have your license in the name of a corporation, the only thing that the company is supposed to be doing is receiving commissions for real estate. It's not supposed to be owning real estate. It's not supposed to be, doing anything else. Open a separate company for that. So again, why would you do a PA? Because it furthers your liability protection, right? Your errors and omissions policies are probably not going to cover you against fraud, breach of duty, breach of contract, negligence, bodily injury, property damage, misrepresentation regarding the condition of the property, any type of violations regarding Consumer Protection Act, maybe some escrow money dispute, misrepresentation regarding flooding or leaks, or misrepresentation regarding the value of the property. Your policy may not cover you against those things. But if you have a separate corporation that you have your license under, then they're not going to be able to attack your personal assets. Of course, you need to have a separate bank account, follow all the formalities, so that you're able to be protected. You'll have what it's called a corporate veil, which is going to separate your liability from your company's liability. The corporate veil is basically a legal concept that separates the personality of a corporation from the personalities of its shareholders and protects them from being personally liable for any type of company debt or obligation. So this is great. Everybody should be forming associations, PAs. Here's a little offer that we have. I think, yes. So we can help you create your LLC, or if you want to, I don't recommend it. We can help you create your corporation, and then we can, assist you in doing all these things, which is obtaining the tax ID and filling out the form that you'll need in order to be able to have your license in your company's name, any type of corporate documents, all of that will be included. If you're interested, feel free to reach out. Please explain errors and omissions insurance. Okay, so errors and omissions insurance, it's the policy against the mistakes that you might do as an agent, but you need to look at the policy. because I don't know, your errors and omissions insurance might be different than this person's. It's like, for example, Geico, right? I may have a policy, you may have the same a policy with Geico, but what you're going to be covered and what I'm going to be covered might be totally different because I pay more or I pay less. So my advice is get the policy, read it, understand what it covers so that you are fully protected. I went to apply for a PA on Sunbase, but could not find a PA. Okay, let me explain. A PA is a professional association. Okay, so it's basically a corporation, right? And at the end, it's going to say PA. When you create this corporation, only certain professionals can do it. It could be realtors, lawyers, doctors, dentists, accountants. So when you form the corporation, in order for it to be a PA, in the reason of what the company is going to do, it has to say real estate related services. And then at the end, you put the PA when you're doing it in Sunbiz, and that makes it a professional association, right? So it's a corporation for professionals, just like a corporation, but for professionals. I don't think I see any other questions.
Good morning.
Good morning.
As a broker, am I allowed to pay the person in their business name or as an individual?
So let's say that your agents form a PA, and now they have the license in the name of the PA. The commission will be paid out to that PA. And Florida allows them to have the name they can only use the real legal name. So for example, let's say I was an agent, the name of my PA would have to be Romy Jurado PA. They cannot come up and do crazy names. They can't. It has to be your legal name. And you can only pay them to their company if they have their license in the name of their company, the real estate license. So it's a little process, but yes, you're allowed to pay them directly.
So if they have an LLC though, what happens?
So they could have an LLC, but it cannot be, how do I explain this? It has to be, their license has to be in the name of that LLC. You can't just pay them because they tell you pay to this company, no, you can't do that. You have to pay their entity that they form with DBPR that they have their license under.
Okay, so it has to show up on the DBPR before I can.
Absolutely. So when you check DBPR, it's going to say, you know, the name of their company, and that's going to be their license, and that is who you can pay.
Okay, awesome. Thank you.
You're welcome. All right, let me see if I see any other questions. Would you put on a slide for corporations? Which one? Let's see. I'm going to send everybody the presentation, and it is being recorded. So, and feel free to ask me any questions now, but if not, I'll definitely send everybody the presentation with a follow-up email. And, you know, any questions that you may have going forward, I'm always available. I like to be a resource for realtors. So feel free to call, reach out by email, text message, whatever you need, so that before you get into trouble, we can see how we can fix it. So I want to thank you all for attending today. I hope you enjoyed it. I really appreciate your time. There is a brokerage that does not have errors and omissions. It only has legal assistant. Is it the same? The agent pays around $600 per year. No, it's not. I don't know what that is. Legal. You mean they have access to a lawyer? If they don't have errors and omissions, then you're not covered. And if you're paying for legal assistance, what does that mean? Like, are you paying for a lawyer? That's a little confusing. I don't know. But every realtor should have errors and omissions. Every business owner should have liability, some type of liability policy. Okay, that's it. All right, guys. Thank you so much. Have a fantastic week. Bye.